The first of these is and by the way, Judge, all of these are fairly short, 1 or 2 pages each, and I have on a couple of them I have attached the key cases that deal with the motion. The first one is a motion to compel an election between the charge of principal and the charge of accessory. And that motion is based on a Florida Supreme Court opinion, which I have attached, and there are a number of cases that follow it, and I've cited them in the motion. But the Supreme Court held in Staten versus State, which is attached to the motion and which is cited in the motion, that the charge of principal and accessory are mutually exclusive. Can't get a conviction for both of those in the same case. The rationale for that decision is that the charge of accessory says that it's a crime to help the principal. If you are the principal, it makes no sense to say that you can also be the accessory. So in short, that's what the Supreme Court said in that case. And I think it bears out in this case, no question that the indictment in this case charges Ms. Williams both as a principal and as an accessory. Count 3 on accessory says she was an accessory to the principal. So in essence, she was an accessory to herself, according to the state's allegations. And so one of those charges has to go down, Your Honor. I mean, they can't get a conviction for both. I think the case...
I think the important question would be when that has to occur. Does this case deal with that?
I think as a matter of law, you simply can't. I mean, there are all these cases. I think the principle that is announced by the Supreme Court is a principle of law.
But it's my belief that the state can pursue alternative theories to the jury, and they do not have to elect before a jury makes a determination. Do you have some case law to the contrary?
There is one. There is one. Well, there is one case that suggests that this is. It doesn't refer to the problem of grand theft and dealing in stolen property, which I know you're familiar with. But Judge Altenburn suggested that most of these cases, the issue came up after the conviction. Judge Altenburn suggested in one of these cases that the remedy would be to instruct the jury that they could only convict of one or the other, but not both. And so I think that's, I mean, I think if the jury were to convict of both, as a matter of law, the court would have to vacate one of these.
Well, that's a typical situation when we're talking about a double jeopardy claim, and typically that decision is made prior to sentencing.
Yes, and I will say this, Your Honor, the case law does hold that it's not a double jeopardy issue. It's a statutory issue. You can't be convicted of both of these crimes.
I said it as an example.
It's really almost like, I think, dealing in stolen property and grand theft. I think it's a very similar situation. So I think that you have to instruct the jury they can pick one. I do take your point that they can file them both. But I think you have to instruct the jury that they can only pick one.
Okay. Thank you. State, want to respond to that?
Yes, Your Honor. As Cora pointed out, in that situation, it would be a situation where we send them both to the jury and alternative theories of guilt, and we would have to vacate one if convicted of both. I think that's the proper procedure. As Your Honor stated, there's no real case law out there that says that it has to be done at this particular time, and in fact, the common practice and what we have always done in accordance with the case law is that we do send them both back and vacate sentences as appropriate.
I'm going to deny the motion at this point without prejudice to raise prior to sentencing should convictions result as to both without any final ruling, because I haven't really studied this carefully, but I think it's likely that what the defense is saying is accurate, but I don't think the timing of it now. I do believe the state can alternatively present theories to the jury, and I don't believe a ruling is required at this point in time.
The second motion, Your Honor, is a motion for judgment of acquittal on the charge of principal in the second count of the indictment. And that motion is based on the same case, oddly enough, Stanton versus State. There's another point in that same case, but there's a more recent case in the First District Court of Appeal, Ammons versus State. It was an opinion, a unanimous opinion by the First District. It was written by Judge Brad Thomas and joined by two other judges on the court. And the court essentially concluded, and I've provided a copy of that with you, that Ammons case. But what Ammons said, and it follows the law, that there must be proof that the defendant committed some act to be a principal. It's not enough just to agree to commit to a crime. That's conspiracy. It's not enough to encourage somebody to commit a crime. That's solicitation. To be a principal, you have to commit some act. And I think if the court could use its own experience, that a lot of these cases where people are charged as a principal, they drove a getaway car, or they provided a gun, or they did something like that. But unless there is something like that, the evidence is not sufficient to charge the person as a principal. Now that comes from the Supreme Court and the first DCA. The evidence in this case, there is no evidence in this case, and I know why you thought this would be quick, because it's credibility of Brian Winchester, whatever we think of his testimony, it's there, and what he says has to be taken as true for the purpose of this motion, and we do. But my point is, there's no evidence even from what he says, that Denise Williams committed some act. If you go back through the testimony, basically what he's saying is that she agreed with him that this would happen, and that's pretty much all she did. And I think you recall when I questioned on cross-examination Agent Mulvaney, who had looked at all of the statements, all the evidence in the case, and I said, Agent Mulvaney, are you aware of anything that she did? Not anything that she said. Are you aware of anything that she did? And he said, no overt act. That was his phrase. So you have a case before you, Your Honor, where there's no act of any kind. And again, her statements could be the basis of some other charge, but not principal. Not under the first DCA decision in Ammons, and not under the Supreme Court's decision in Stanton, both of which I've provided you.
I have. Oh, okay. The other one was attached to the first motion. I'm sorry.
Yeah, I'm sorry. I didn't make two copies of that.
No, you didn't need to. You didn't need to. I just misunderstood. Give me a second.
Yes.
Go ahead, Mr. Hughes.
Your Honor, the Brian Winchester's testimony is part of the plan was that she was to take the affirmative step of making sure that Mike Williams could go on this hunting trip. That was no small feat given the fact that it was on their anniversary. That is an overt act by Denise Williams in accordance with through the testimony of Brian Winchester that would constitute the principal aspect of the first-degree murder in this particular case, and certainly given in light most favorable to the state, that would be an overt act in that situation.
So, Mr. Padavona.
He said that in his deposition, but I don't recall him ever saying that in this trial. He basically said that they agreed that this would happen. In his deposition, he said that her role in it was to give permission to go hunting. But my recollection of the testimony is he never once said that in the trial. What she said to him, first of all, I think it's doubtful that that constitutes an act. Maybe you could say it's a verbal act, but I mean, my point would be, how far do you want to stretch it to get to the point where she is a principal? My understanding of principal is somebody who actually does some hard thing to help somebody out. Buys a gun, supplies a gun, drives a car away, something like that. There's nothing like that in this case.
Your Honor, with all due respect to DCA, the Supreme Court of Florida has issued the jury instructions as it relates to principal, and that in itself says the defendant did some act or said some word was intended to, which caused the did incite, cause, encourage, assist, or otherwise advise a person to actually commit the crime. So,
Your Honor, if I could be permitted briefly to address that.
Certainly.
Mr. Hughes is correct about that. And my response to that is that the jury instruction, which the court is not, the opinions all over the place that say the jury instructions are not the law. But here's where the bottom line of our argument is on that. He's correct about that. The jury instruction says that, but the bottom line of our argument is the standard jury instruction is wrong. And I am also, when we get finished with this, I'm going to ask you to change it. Because nowhere in the Florida law does it say that you can be a principal of the crime just by giving somebody else the okey doke to do it. That's not the crime. So the jury instruction is wrong. I think if it comes down to following the jury instruction or following the case law, I think the court's duty on that is clear.
I'm going to reserve ruling on that for the moment. I have a little better chance to read these cases and understand them a little more carefully.
So the third one is the defendant's motion for judgment of acquittal on the charge of accessory after the fact. And let me say, before I start that, I'm a little bit unclear, even myself, what evidence the state thinks is accessory after the fact. So I'm not sure what it is they're relying on. But the indictment on count 3 has a fairly narrow time window, fairly late in the game. I think it's something like 17 through some period of 2017 through 18 or something like that. And the only thing that I can think of in the testimony that they were relying on is her interview with Devaney when she refused to give information. And the point of this motion is that there's case law in Florida requires for a conviction for accessory after the fact, the case law requires an overt act. And the cases have said, in other words, you have to do something affirmatively to mislead the police. You can't simply go in and in a police interview and deny that you know anything about it. In the case that I have attached to the motion, there's not a whole lot of law in this, but the one case that I do have attached to the motion is that Melan case, if I'm saying it right. Essentially says that if all you did was interview with the police and claim that you knew nothing at all about the crime, that's not being an accessory after the fact. There are some things in this case that I think might have qualified, maybe thwarting the investigation, with Cheryl Williams. I don't know, but if you look at the time frame in the indictment, there's almost nothing in there except interviews in that period of time, except interviews with law enforcement officers. And there isn't anything that she did. In fact, on numerous occasions, she cooperated with them, turned over the note on the car. The incident at FSU, she went straight to the police. So if what the state is relying on here, and again, I say I'm not sure, is that she refused to talk to, she denied, let's say she falsely denied, that's really taking it in the light most favorable to the state, falsely denied knowing anything about it, that's not enough to prove the crime. There has to be some overt act that she did to try to mislead them, and there really isn't anything.
The overt act by Mrs. Williams is the message that she sent to, or attempted to send via Kathy Thomas. What she did is she told law enforcement to deny the involvement aspect to law enforcement, but immediately thereafter, within the week, she sent a message to Brian, essentially her co-conspirator, to let him know that the agreement, if you take Mr. Winchester's testimony about the agreement about not cooperating and everything along those lines, don't time each other out, she sent an affirmative act that was towards the goal of keeping them from being arrested and keeping him from being arrested. She sent him a message saying, I didn't tell him anything, so therefore you shouldn't tell him anything. And again, the entire purpose of that is to keep him from confessing, to keep him from implicating her along those lines. So that is the affirmative act that was done that goes beyond just denying it to law enforcement.
The note doesn't say, therefore, you don't tell him anything. I mean, he's sort of extrapolating from that note. I mean, that's not evidence of obstructing the police.
But I think that is an overt act. Frankly, I think there are things, as mentioned by the defense, that are more clearly that kind of activity, particularly the dealings with the Williams, but that's not what's alleged. But I'm going to deny that motion. But we're not going to argue that to the jury.
No.
I'm talking to the state now. So we're not going to argue it's accessory after the fact is based on what was the conversation with the Williams, which is years before the allegations in the indictment in terms of accessory after the fact. You understand, Mr. Fuchs?
No, actually, I'm trying to figure out what conversation you're talking about.
When Denise Williams allegedly goes to Miss Cheryl, I'm sorry, I may have the names wrong. I'm sorry. Goes to the grandmother and Mr. Williams' brother. We're not going to argue that as being the accessory after the fact, although I think it could have been charged that way.
I am intending to use those things for other purposes, but
Certainly.
I'm not using it for the accessory after the fact purpose.
Certainly. Right.
I agree with that, Your Honor. I think
Okay.
that's fair. I mean, it's relevant, but it's not the basis of the accessory charge, and I think that's what the court is getting to, and I think counsel understands that. The final motion is the motion for judgment of acquittal on the charge of conspiracy, and I didn't put a case in here because I don't need to outline for the court what the elements of that are. But just looking at the facts, I think it's fairly clear from the evidence that, from the state's evidence, that she renounced the conspiracy on December 9th. By Brian Winchester's own testimony, I think he said he called Mike Williams, and Mike Williams said to him, "I can't go hunting," and then something to the effect of, Brian then called Denise Williams after that and said, "Well, what gives? I thought we were going to do this," and she said, "I had cold feet." So you have a scenario in which Denise Williams is preventing him from going hunting and explaining that she's changed her mind. So that, I think, amounts to a renunciation of it, and I know that there is a part of the conspiracy argument which you had highlighted on your draft of it, which talks about that. We're going to ask the court to give that, but just as the beginning part of this motion, the reason I bring that up is because I think that really the court needs to look only at what happened in the intervening week. And I will say, not much. Brian Winchester himself said that he had very minimal contact with her that week. There's no evidence of any sort of plan that occurred that week. I just don't, I mean, I just don't think that what happened between December 9th and December 16th can support a charge of conspiracy.
I deny that motion.
All right. Then, the final thing is the request for a modification of the jury instruction.
We'll take that up after you.
Only reason, I'm happy to do it later, Your Honor. I know you're concerned about getting jury instructions early.
Oh, I appreciate that.
If you're okay with me doing it later, I'm okay.
If you have a proposal, I'd like to see it, but I don't want to get into argument on it at this point.
No. Well, I don't think there's any need for argument. It's basically what we argued on the motion for judgment of acquittal on the principal charge.
Okay, thank you.
Thank
All
you.
right. Veronica, do you need a break? Do you need a break? All right. Defense have their first witness ready.
Can I check with Mr. Way, get that
Certainly, certainly.
Yes, I've told you.
You get Mr. What? We ready for a jury?
Your Honor,
This is the proper.
We'll do that at lunch. We'll do that on our time, not their time.
Understand, Your Honor.
Get your first witness that you want to call?
The defense calls Kristen Gonzalez, Your Honor.
No, we're not going to take a proffer now. You weren't listening. We'll do the proffer at lunchtime.
I apologize, Your Honor, but we're going to be part of her testimony. I'll get the next one.